All right, good afternoon, everybody, and welcome to the Palisades Village presentation of Phil Kenny from the Collins firm on estates and trusts. Phil's an attorney and a member of the Trust and Estates section of DC, Maryland, and Virginia Bar Associations. He's a frequent guest host on Mike Collins' Saturday morning radio program on estates and trusts on WMAL, and he's a member of the Bar Associations of Maryland, DC, and Virginia. He earned his BS in biology from Marquette, MA in economics from Fordham, and his JD from George Mason. And I think, Phil, how long have you been with Collins firm?
What day of the week is it, Wally?
Yeah, okay. I think it's 25 years, I would guess.
Since 1994.
94. Do the math. It's close to 30 years. I got one story I want to tell about Phil, and I don't know if he knows this or not, but early on after he got hired, I was talking to Mike Collins, and he had just hired Phil, and he said, when I was interviewing Phil, one of the jobs he told me that he had was going door to door selling encyclopedias. And Mike said, if a guy has chutzpah enough to do that, I'm going to hire him. Did he ever tell you that, Phil?
No, but I knew that was something we had talked about, and then he was impressed by that. So
yes. So okay, I'm turning this over to Phil. Take it away.
Okay. Thank you, Erica. Thank you, Wally. Thank you, everyone, for joining us today. Yeah, it's a beautiful day out there today. So we'll try to keep it under an hour. And what I'll do is I'll talk for the first half hour or 45 minutes. And then at the end, we'll take your questions. So I don't want to stop and take questions as we go along, because then, it might be something that I'm going to cover in a few minutes anyway, or we don't want to kind of disrupt the flow. So if you could just make a note and write down your question. If I don't cover it at some point in this, then certainly we'll cover it. Take your questions at the end. So I do enjoy giving seminars and talking to people. And when I start to talk to a group, I always think about, so what are my goals? What do we hope to accomplish today? And the two-word phrase is always educate and motivate. So educate, what I mean by that is simply make you aware of what the issues are. For a lot of people, I talk to them about estate planning, and it's kind of like an eye-opening experience. Like, whoa, I never knew that, or I never thought about that, or I didn't know you could do that. So just to kind of make you aware of what the issues are, educate you, but also motivate you. Because I do a lot of estate planning for a lot of people and continually get the phone calls. I had one earlier this week. Mom is going downhill fast. I met with her a year and a half ago to do her estate planning, and I get the call from the daughter, mom's going downhill fast, kind of panicking. We're all guilty of procrastinating. So hopefully I can motivate some of you to take action long before it becomes an issue, so that you're not scrambling at the end, so that you're not, putting your family under extra strain and pressure. You just want to kind of get this all done, get your affairs in order, and have that peace of mind of knowing that everything is going to go as smoothly as possible for your loved ones. So educate and motivate. That's my goal today. There are 4 areas, 4 topics that I think about when we talk about estate planning. The first one is estate taxes. So we'll talk a couple minutes about estate tax. There's a DC estate tax. There's a federal estate tax. Many jurisdictions like Maryland have an estate tax. Pennsylvania has an inheritance tax. So we'll talk a little bit about estate taxes. We'll talk about avoiding probate. What is probate? How do we avoid it? Focus a little bit more on incapacity planning. Really the thing that I emphasize most with every single client is if you had a stroke or dementia, what are the issues? How can we address those? And then addressing any family circumstances or concerns that there might be. Situations you wish were otherwise, second marriages, all kinds of issues out there. So we'll talk a little bit about how to address those concerns. Then a little bit about our firm and our services and our fees and how we do everything. And this is just kind of general commentary and isn't going to really apply to any particular person's circumstances. In order to give you really good advice, we would have to meet in person in confidentiality. I'd have to know a lot more about you to be able to advise you. So for attending today's Zoom meeting, you're entitled to come in and I'll sit down with you for a free consultation. And we can go over your personal circumstances. So feel free to get in touch with my office. Just let them know that you attended the Zoom conference and that you wanted to take us up on the offer of a free consultation. My office is in McLean. I work out of the McLean office. So if you're willing to come into McLean, I can meet you here. We could do a Zoom meeting if that's more convenient for you as well. But you're all welcome to come in for a free consultation. So estate tax. The first thing to know about estate tax is the concept of the gross estate. That is what is includable in the decedent's gross estate when someone dies. And it's the obvious stuff. It's like the value of your home in your bank accounts, and it's the value of your mutual funds or brokerage accounts. It's also maybe not so obvious stuff. For example, life insurance. When I meet with a client, we're going to run down your assets and I'm going to ask you, how much life insurance coverage do you have? And, people will say, well, it's just term insurance, or it's just through work, or it's not much. But when someone dies, that life insurance, those proceeds from the insurance company is includable in the decedent's gross estate for estate tax purposes. So when you want to know how much life insurance coverage you have, retirement accounts, pension benefits, kind of add all this up. And that adds up to what's called your gross estate, or think of it as your net worth plus life insurance and other assets. And if your estate is above a certain level, your estate could be subject to both a federal or a DC estate tax. The good news is that we have exemptions. The exemptions are relatively high. The DC estate tax exemption is currently $4 million. Anything above the exemption amount is taxed at a rate of 15% in the district. If anyone lives in Maryland or has property in Maryland, the Maryland exemption is $5 million. Here in Virginia, we have no estate tax whatsoever. So in Virginia, we're only worried about the federal estate tax. And currently the federal estate tax exemption is $12 million. But this is subject to change. There is a sunset provision in the year 2026. The latest tax cuts expire. And it goes back to $5 million indexed for inflation. So it's going to be at least $6 million in 2026. Anything above the federal exemption amount is taxed at a rate of 40%. So if you're at those levels, you don't have to be very far above the exemption to have a very significant estate tax liability. Now, for a married couple, we're typically going to want to do a little bit of tax planning for a married couple, which involves using both exemptions. So if you're married, you and your spouse each have an exemption, and a married couple can combine and use both exemptions. So in DC, a married couple can shelter up to $8 million by using both of their exemptions. And how we're often going to do this is by creating a trust, a revocable living trust. And what we say in the trust is that when one spouse dies, we sit down and we meet with the surviving spouse. And we take a look at your estate size, and we take a look at the exemption amount. And if you're a married couple and you own a house and some retirement accounts, and it adds up to, $2 or $3 million, and the exemption is 4 million DC or 6 or 12 federal, then you do nothing. There's no estate tax issue there. It remains one revocable living trust. But if one spouse dies and you're at or above that exemption amount, the surviving spouse can split the trust into what we often call an A and a B. And it doesn't matter which spouse goes first, but if the husband died first, dad's half goes into trust B for mom's, the surviving spouse's sole benefit, utilizing and sheltered by his exemption. The surviving spouse's half is in trust A. And as the surviving spouse, she's going to be the trustee and beneficiary of both halves, A and B. And the benefit of this AB splitting is that the B trust is what we call the bypass trust, meaning when the second spouse dies and you want to pass everything on to the kids, for example, dad's half, the B trust, bypasses mom's estate and goes to your children estate tax free. In the A portion, mom's half is going to go to the kids, utilizing and sheltered by mom's exemption. So we call that the AB trust. This is just tried and true basic estate planning for a married couple. And if you have an existing trust or an existing will, you may have this planning in your documents right now. It's very common, very routine planning for a married couple. And if your documents are more than 6 or 7 years old, I'd highly encourage you to meet with your attorney and have that tax planning reviewed, because there's been some really significant changes. The exemption amounts have really shot up over the past few years. When I first started practicing law back in 1994, the exemption amount was $600,000. So it's really gone up significantly. And what that means is if you have tax planning in your documents, it could be outdated. It might need to be tweaked or updated. So educate and motivate. There's a federal estate tax. There's a DC estate tax. For most of us, we're going to be below those numbers, so it's not that big of a deal. But if you are close to those numbers, you're above those numbers, there's a lot of things that you can do to minimize that estate tax for your kids and for your family. Now, another big issue that we want to address in estate planning is we want to avoid probate. And first, to explain probate, what is probate? A lot of us have heard that term before. Probate has nothing to do with estate tax. Probate is not a function of your estate size or your net worth. Probate is really just the practical matter. How do we go about getting the assets out of the decedent's names, into the kids' names, into the beneficiaries' names? That's it. And probate happens whether someone dies with a will or intestate, no will. So will or no will, there's a probate. And I make this point because it's a fairly common misconception I meet with a lot of people, and once a week, I'm going to meet with someone and they're going to say something like, well, Phil, I went to this nice lawyer and I've got a really well-written will. It says exactly what I want. I'm very, very happy with it. Isn't that good enough? Like, as in, shouldn't my estate avoid probate? And of course, the answer is nope. It's not how it works. When someone dies, your executor must physically in person take that will to the courthouse. You've got to file the will, file the inventory, publish the notice, wait the statutory waiting period, do the final accounting. Probate is basically a bit of a bureaucracy. And even though the 3 local jurisdictions have different procedures and there's different costs and fees, there's 4 basic issues with probate. Number one, there are court costs and there can be attorney's fees. Here in Virginia, where I practice most frequently, the court costs run 0.2% of the estate in probate. So 0.1% with the initial inventory, 0.1% with each accounting. So for example, a couple $1 million going through probate is going to be about $4,000 in court costs. Roughly the same in Maryland and DC. Attorney's fees, having to hire a lawyer to probate that will could easily run $15,000, $20,000 in attorney's fees. Delays, a probate will often run 9 to 18 months, but it's really just hassle factor. Trips to the courthouse, gathering information, trying to get the paperwork in time. Probate is a wide open public process. The whole purpose of probate is to give heirs and creditors a chance to step forward. And potentially there could also be something what's known as an ancillary probate or additional probate. A lot of my clients live here in Northern Virginia and have a second home or a rental property at the beach in Delaware or North Carolina or Maryland. Many clients own half the family farm back in Iowa or Illinois, or the homestead in Pennsylvania. Or maybe you own a condo in Florida or a timeshare. A lot of people own timeshares. And the issue here is that real estate is always probated in the jurisdiction where it's located. So if you live in Virginia and you own a beach house or a condo at Ocean City and half the family farm in Pennsylvania and in a timeshare in Florida, and you died, that would be 4 separate probates. The real estate would be probated in each of those jurisdictions. So very common scenario. Now, we can avoid probate. We avoid all of probate easily and readily with a trust, with a revocable living trust, revocable. You can revoke it or change it or amend it whenever you wish. And we create the trust and then we fill up the bucket, meaning all the property, all your real estate and accounts, everything that you own needs to be properly titled to, quote, get it into the trust, to get it into the bucket. So your home, we would prepare a new deed for your home and then take care of getting it recorded for you in the local land records. And it doesn't affect anything. If you have a mortgage on your house, you don't have to contact the lender or refinance. There's no transfer taxes. It's a nominal recording fee. In DC, it's $36.50 to get the new deed recorded in your name as trustee of your trust. So we create the trust, we fill up the bucket, and then in the event of your death, your trust continues in existence. And someone called your successor trustee takes over. So it could be your son or your daughter or whoever you choose, a family member. But quite literally, with a copy of the trust and your death certificate, they can sell the house and pay the bills and make the distributions. No courts, no filings, no waiting periods. Don't have to hire any lawyers. Give them a little help. So we want to avoid probate. It's really very, very easy to avoid probate with a revocable living trust. Now, the biggest issue, the most important thing that I emphasize with every single client is incapacity planning, which is admittedly not any fun to focus on, but stroke, dementia, these kinds of issues. And what we want to do, the threshold issue, is we want to avoid legal guardianship. So if you're married, think about what you own. You know, you and your spouse are undoubtedly both on the deed to the house. So if dad dies, mom owns the house automatically by right of survivorship, not a problem. Most of us these days have a lot of our savings in a IRA or 401k or thrift savings plan if you work for the government, and guaranteed you've got your spouse as your beneficiary. So if dad dies, mom gets the TSP, mom gets the IRA, the Roth automatically. Not a problem. The problem would be, what if dad didn't die? You know, if dad had a stroke, dementia, or a car wreck, if your spouse is incapacitated and you want to move, you're basically stuck because you're both on the deed and one spouse cannot unilaterally sell the property on their own. Or that IRA, that 401k, being a wife, being a beneficiary of that TSP, does not give her any access to that account while the participant is living, even if incapacitated. If no planning had been done ahead of time, you'd have to go to court. Have to hire a lawyer, have your spouse declared legally incapacitated, get qualified as the guardian. It's the worst case scenario. It truly is. It's basically a probate for the incapacitated called guardianship. And the good news is we can avoid guardianship very, very easily, very readily. Step one is a document called a durable general power of attorney, or power of attorney for short. But in the power of attorney document, you will give your spouse, you will give your son or a daughter or family members. You can name some backups. So typically the power of attorney is going to list 2 or 3 people. But you're going to give your spouse and loved ones that legal authority, that capability to be able to access accounts and write checks or pay bills or file taxes and manage the family finances on your behalf without going to court. So critically important, we do powers of attorney for every single client without exception. Additionally, we address this whole issue with your trust. Again, we create the trust, we fill up the bucket. And if you're a married person, typically you and your spouse will be co-trustees. So we'll have both spouses on the trust. And under the terms of the trust, the co-trustees can act independently. So if one of you has a stroke or dementia, the other spouse can manage everything that's in the bucket. And then you'll name your kids typically as your successor trustees. So if dad died, mom becomes incapacitated, then the daughter takes over. She can manage everything for mom without going to court. And what we're typically going to say in the trust is that 2 physicians must certify in writing that you're not capable of managing your financial affairs. So it's going to be your attending physician, your primary care physician, the specialist, but it's very simple. It's very straightforward. It's kind of standard operating procedure. I've examined the patient. She's suffering from dementia. She can't manage her finances. Signed, Dr. So-and-so. And again, the goal here, avoid guardianship. We don't have to hire lawyers and have to go to court. The third tool is a document called an advance medical directive. The advance medical directive has a portion often referred to as the living will. This is the part that says, if I'm actually dying, I'm terminally ill, I'm in a hospice situation, let me go naturally. Don't artificially drag things out. Or if I'm in a permanent coma, like that girl, Terry Schiavo or Karen Ann Quinlan, I don't want to be permanently kept a vegetable. You know, when I get to that point, let me go naturally. Pain-free, but naturally. More broadly, your advanced medical directive is a power of attorney for healthcare. you're going to give your spouse and your chosen family members the ability to visit you in the hospital, talk to doctors, access records, speak on your behalf. And really, frankly, a much more likely scenario. One day you're going to be in the hospital, not terminally ill, you're not dying, not by a long shot, but you're sedated, you're medicated, you're out of it. You want to make sure that your spouse and your kids can visit you and speak on your behalf. We put the HIPAA language, those federal privacy forms that you sign when you go to the doctor. No one gets anything automatically. Being married does not give you automatic access to your spouse's healthcare records. Being a son or daughter does not give you access to your mom and dad's healthcare records. You want to have it in writing in advance. And typically what we're going to do is you'll come in and sign the documents in our office, pen on paper. We have the witnesses and the notary, and then we'll scan and email you a PDF of your advanced medical directive, so you can forward that to your primary care physician. You can forward it to your son or your daughter, but it's a good idea to get that out there well in advance. So again, not fun to focus on. No one likes to think about themselves in a hospital bed. But truly, I emphasize that as the most important part of your estate planning. You know, just great peace of mind, knowing that everything is taken care of well in advance. Another big part of the estate planning is planning for and protecting children and family members. You know, as an estate planning attorney, you quickly learn the adage that dysfunctional family is a redundancy. You know, almost all of us have some circumstances in our family that we wish, you know, were otherwise. And when you come in and meet with your lawyer, you know, don't be embarrassed, or, you know, we have attorney-client confidentiality. I've heard it all before, but let's talk about, you know, what's keeping you awake at night. You know, so if you're worried that your daughter's marriage is kind of rocky, or maybe someone's drinking more than they should, or someone's, you know, pretty far in debt. A lot of times there's some really basic things that we can do in terms of your estate planning to protect that person's inheritance from their personal situation. I meet with a lot of families where there's a child with a disability or a grandchild with a disability. And there's some planning opportunities there as well. If a person's disabled, you know, you can't really leave them a whole bunch of money. They don't have the capacity to manage that. So you're going to leave it to them in trust. Typically, you're going to want to pick a family member to be the trustee for them. If there is no good choice there, then we can talk about naming a corporate trustee. That there are lots of banks and trust companies out there that could be named as a trustee for someone. People with disabilities are often eligible for government benefits, such as Medicaid. But Medicaid is a means-tested program. If you have your own resources, you're not eligible. So we're going to leave it to a person with disabilities and what's called a supplemental needs trust, so that the inherited money in that supplemental needs trust is not an available resource for purposes of eligibility. It doesn't jeopardize any government benefits that they were otherwise eligible for. Second marriages, you know, very, very common planning scenario. If you have children from a previous relationship, if you've got separate property, a lot of times what we're going to do, you know, for a married couple in that situation is, you know, talk it through. You know, is there a prenuptial agreement? Is there separate property? You know, what are your plans? But what we don't want to happen is an accidental or unintended disinheritance. And a lot of times this is what happens when there's a failure to plan. If you're in a second marriage situation and, you know, you love each other, you love your new spouse, and you plan on leaving everything to each other, which is great, no problem there. But the problem comes on the second death. So if dad remarries and then dies and everything goes to stepmom, if there's no planning in place, when stepmom dies, everything goes to her kids from the first marriage. Nothing goes to dad's kids. And typically, this is not how people plan it. When we talk about these things, no, that's not the intent. We want to leave it equally to both sets of kids. So by creating a trust and then filling up the bucket, you can leave those assets in trust for your surviving spouse. But when the second spouse dies, everything goes, to where, the two of you agree, to both sets of kids equally, or however you want to do it. So all kinds of situations out there that need planning, and we can talk that through. A lot of my clients I meet with are successful professionals, and their kids are successful professionals, and they're in good jobs and solid marriages, and healthy and well employed, and not a lot of concerns there. And what we're often going to do for a family in this situation is we're going to recommend you leave it to your son or daughter in what we call a reservoir trust. So reservoir trust is our firm terminology. It's just what we call it in our practice. It's kind of like our brand. And, let's say a married couple has 2 kids. So after mom and dad are both gone, they can leave it to their 2 children equally in 2 separate reservoir trusts. So your son gets his half in his name in his reservoir trust. Your daughter gets her half in her name in her reservoir trust. 2 separate trusts. And they can use it, they can invest it, they can spend it. We're not trying to restrict them. We're not trying to control them at all. The purpose, the benefit of this reservoir trust is it provides very significant protection. If at some point down the road, one of your children ever divorces, the inherited money, that reservoir trust, is your son or daughter's separate property. It has not been commingled with marital assets, so it's not split up with the next spouse in a divorce situation. Many, many years ago, when I first started practicing law, met with a client here in McLean, and he told me how that when his mom and dad died, he got a substantial inheritance. He takes this money, he pays off the mortgage on the house, he puts it in the joint account with his wife. He commingled it with all their marital assets. Little over 1 year later, she left him. She got half of everything. Says he never saw it coming. So instead, you can leave the money to your son or daughter in a reservoir trust. They can use it, go out to dinner, pay for vacation, use it for their kids, and whatever they spend is gone. But whatever remains in their reservoir trust is always separate property, not marital, not commingled, not community property on the West Coast, protected. But a lot more from that. It's also protected from creditors' claims if one of your kids ever got sued. So whether it's work-related, doctors, lawyers, engineers, entrepreneurs, always worried about professional liability, or negligence. If one of your kids was texting and driving and looking at their phone and just ran a red light and injured somebody, or credit cards, or foreclosure, or bankruptcy. If your son or daughter ever got sued, their reservoir trust is shielded from lawsuits, shielded from creditors' claims, protected. We build into the trust what we call a standby supplemental needs trust. We're going to say that if at some point down the road, one of your kids or grandkids, if anyone was ever injured or disabled, instead of a reservoir trust, they get their money in a supplemental needs trust, again, which doesn't jeopardize benefits they were otherwise eligible for. So we had a client die recently, and her daughter was recently diagnosed with MS. And she does not have a lot of resources of her own. So the daughter with MS is going to get her inheritance in a supplemental needs trust, because if her illness progresses and she winds up in a nursing home at some point, she'll be immediately eligible for Medicaid, and that inherited money does not jeopardize her benefits, protected. And then in the event of your child's death, you're typically going to say the remainder goes to his or her children, your grandchildren, per stirpes. So per stirpes, people always laugh about that. Legal shorthand. It means by right of representation, so that it never gets out of date. You know, whether your son or daughter has 2 kids or 3 kids, 4 kids, when your son or daughter dies, the remainder goes to their children equally. And typically it would say if one of your kids dies before having had their own children, then everything goes to the sibling or the siblings' kids. It follows your bloodline. So hope for the best, prepare for the worst. You know, that's the essence of estate planning. You know, hopefully there'll never be a premature death or a divorce or a lawsuit, but stuff can happen. And this is a buffer. It's a layer of protection to help keep your money in your family. So I've mentioned trust many, many times. A trust is set up and established by someone known as the trustor. That's the creator of the trust, and that's you. You are the trustor. You're the creator of your own trust. Synonyms are grantor or settlor. And as the trustor, as the creator of this revocable living trust, you retain the right to revoke it or cancel it whenever you wish. But almost never does that happen, like literally never, because you can amend it whenever you wish. You can change the trustees, you can change the beneficiaries, you can pull assets out or add assets in whenever you want. You have 100% control of everything as the trustor, as the creator. Additionally, you are the trustee of your trust. The trustee is the person who's the legal owner of all the assets. So you are your own trustee. Everything you own remains in your name. It's just that it's a qualified ownership. Now you own it as a trustee instead of as an individual. And additionally, you are the beneficiary of your trust. You are the equitable owner. You've got the right to the use and enjoyment of all your own assets for as long as you're alive. So it's kind of artificial in that sense. You're the trustor, you're the trustee, you're the beneficiary of your own trust. I like to think of this as me, myself, and I. But that's the nicest thing about a revocable living trust. You see, because you are all 3 roles, the trustor, the trustee, and the beneficiary, your day-to-day life, it's exactly the same. Life's exactly the same with a trust. So we create the trust, and then we're going to fill up the bucket. So the deed to your home and your accounts and your beneficiaries, and we help. This is a big part of our service. And whenever you want, you can buy or sell or mortgage or refinance. You write checks and pay bills, manage your money the same way. You are required by law to file the same exact income tax return. You do the same 1040 that you've always done. The trust tax ID number is your social security number. There's nothing extra, nothing different, nothing additional to do in filing taxes. The thing to be diligent about when you have a trust is whenever you acquire new assets. So if you were to move money or open a new account or get an inheritance, whenever you acquire something new, they're going to say, how would you like your new property titled? And you're going to take title to it in your name as trustee of your trust. And you're done. That's it. That is, if someone were to pick up your trust document and start paging through it, the trust does not list the assets. Nowhere in the trust does it say that you own a home or a bank account or an IRA. No, it's the deed with the land records that reflects your name as trustee of your trust. It's the signature card at the bank or the credit union. It's the beneficiary with your life insurance and 401k that all reflects the trust. Now, the benefit of this whole arrangement comes mainly from the fact that spelled out in the trust are your successor trustees. So if you became incapacitated, again, if 2 doctors put it in writing that you can't manage your financial affairs anymore, then your successor trustee takes over, your son or your daughter. And they step into your shoes, into that role as trustee, and can manage everything on your behalf without going to court. We avoid legal guardianship. In the event of your death, the successor trustee takes over with the trust and the death certificate, that they can sell the house and pay the bills and make the distributions. No probate. The trust acts like a will. The trust has your distribution plan written into it, just like a will. Key difference, no probate. So whether it's a reservoir trust for your adult child, or a supplemental needs trust for your beneficiary with a disability, or however you want it done, no courts, no filings, no waiting periods. Now, we still do a will for every single client. Matter of fact, in a typical estate plan is going to have the revocable trust as the centerpiece, is the heart of your estate plan, but it's also going to have a will. We call it your pour over will. If something was forgotten or left out, I want that one item poured over into my trust. Power of attorney, medical directive, HIPAA. There's a tangible property memorandum. You can list who gets the personal items like the jewelry and the artwork, antiques. Oftentimes it's going to be 8 documents in a 3-ring binder. You keep it in your own home. We have copies, and we can even email you a PDF these days. You can have electronic copies. So again, you're welcome to come in for a free consultation. I'll sit down with you. We'll go over things in detail specifically for your situation. We'll talk about whatever services and documents you need. If you have a trust already, bring it with you. I can review it for you right on the spot. If you've got planning documents already, come on in, free consultation. Take a look at it. We'll see what needs to be updated or revised, if anything. All of our services are provided on a flat fee or a fixed fee basis. Often we're in the $4,000 range. Really depends on how big your assets are, and how many properties you own, and really what you own. But it's a free initial consultation, and we do everything on a flat fee or a fixed fee basis. So you're never worried about how many meetings or questions or drafts or phone calls. Other thoughts, and also there's always a free consultation for the surviving spouse, and a free consultation for the successor trustee. So in the event of your death, we'll sit down with your spouse, surviving spouse, we'll sit down with your kids for a free consultation to get them off on the right foot as well. So I think that is about 45 minutes in now, leaving us about 15 minutes or so for questions. So I don't know if anyone has any questions. I probably did such an amazing job going through everything that no one has any questions whatsoever. But if you want to
see any in the chat, so
raise your hand or type in a chat question, or unmute yourself and shout it out.
Leslie Cohen.
Right. Yeah, that's my wife's name. She's here with me. I'm Dr. Max Cohen. But 2 things. First of all, it's said that if you have, let's say, just a small joint checking account, that you need not put that into the revocable trust, just because it might create a little more work than is necessary. But the other thing is the consideration of portability, which is that if a spouse dies, the executor for that spouse on the estate tax return form 706 can say that the unused portion of the estate tax exemption of the spouse that dies gets transferred over to the spouse that is surviving. That sometimes is useful. I'd like your opinion about that, but that's something that's effective both, of course, on the federal since 2010 and also in the state of Maryland, for example.
Yeah, so on the joint checking account, that's a very good question. I'm so glad you brought that up. but I could not recommend more getting it into your trust. So number one, you'd hate for your kids to have to go to probate over a small checking account. So make the extra effort, get it into your trust. A lot of times what we can do these days is you can add what's called a POD, or a pay on death beneficiary. You can name your trust as the beneficiary of that checking account without changing any account numbers. Because I get it. I mean, you don't want to have to shut down the old account and open a new account and mess up all your automatic deposits and automatic withdrawals and get new checks printed.
But if you have the wife if it's a joint account with your wife and you pass away, of course, your wife can handle it. And of course, if you're disabled, your wife can handle it.
Right. But eventually she's going to die too.
After the second, I agree with you, after the first spouse has died. And especially if it's a significant amount, you might want to.
So don't tempt fate, don't procrastinate. Get it in the trust right now while you're thinking about it. Because your wife, she's going to be grieving. She's going to be incapacitated with grief
for years.
She won't be able to get it in the trust. Yes.
Right. Now, what about portability? Did you have anything to say about that?
Portability, kind of way beyond the scope of a Zoom meeting on estate planning, but certainly another arrow in the quiver of estate tax planning is the portability election. You summed it up quite succinctly. Thank you. In the event of a death, you can, instead of funding that bypass trust, you can file an estate tax return and make an election to inherit the deceased spouse's exemption. Now, this is, I think of it as the pour over will. You don't want to, it's typically not going to be our first choice. If you are at those levels where you do have an estate tax liability, first choice is always going to be to fund the bypass trust, because the exemptions are quite high right now. Chances are they're going down. I mean, the Democrats were campaigning on lowering it to 3.5 million, which didn't happen because of the Senate. But in the future, the exemptions are likely to be much lower than they are now. So if somebody dies, we want to take advantage of the full exemption. When under portability, you get the exemption, not an amount. So whatever that ticket is worth on the second death could be a lot less. There's also a whole nother level of sophisticated estate planning called generation skipping transfer tax planning, that the GST exemption is not portable. But sometimes we'll meet with the widow and there was no planning in place. And, she's just kind of beside herself when she sees the numbers, the potential liability for the kids of not having done that planning. But we can kind of pull a rabbit out of the hat and save the day by making a portability election. But that's also fraught because it has to be done within 9 months of the date of death. It's not easy to file an estate tax return. It's quite expensive. It's a huge return that requires a lot of detail and a lot of work. It's often, more economical to fund the bypass trust than to have to file an estate tax return. So,
with regard to the bypass trust, I wonder whether it should be mentioned that IRA funds, if a person's estate consists largely of Roth and traditional IRAs, that usually passes by way of the beneficiary designation and therefore doesn't have to go through the bypass trust. In fact, it's a critical mistake, I believe, to make the estate the beneficiary of an IRA.
Yeah, that's exactly right. More so than ever after the Secure Act. If you're married, you always want to keep your spouse as the primary beneficiary and have the trust secondary beneficiary. Typically, how we do that. So if you're a retired physician with a big huge pension plan, maybe you can't run that through your bypass trust. So that would be a good case where portability would be a good option.
Right, and the last thing I'll say is that with regard to the amount of funds that are portable, if you die and at the time of your death, $5 million is portable, let's say in the state of Maryland, and then 4 or 5 years later, your wife dies, is the portable amount determined by the amount that was in effect at the time of the first death by the husband? Or I would think it would go by what it is in effect at the time of the second death of the wife, for example.
Correct. That's right.
So
Yeah,
there's an
we have
element of
more- oops.
unpredictability.
Okay. We have some more questions out there in the chat. Someone was asking, for a couple, would you just have a single trust or separate trusts for each partner?
Very good question. If you're a married couple and you're only married to each other and everything is joint and you only have each other's kids, typically one trust for the married couple is more natural, and that's going to be a better fit. If you have separate property, if it's a second marriage, if it's a more complicated, then two separate trusts would probably be more comfortable for a couple in that situation. So it's up to you, your family situation.
And then someone was asking, when do you recommend using or needing a trust?
So there's no bright line fact or number or figure. It really depends on the facts and circumstances of the person's estate. So it really depends, but certainly if someone has less than $300,000 or $400,000, it might not be economical to do the trust, but just about everybody could benefit from it.
Okay. Next question. What counts for the DC estate tax as opposed to federal estate tax?
Yeah, good question. So if you're a resident of the District of Columbia, again, it's your entire gross estate that would be subject to the DC estate tax.
Same in Maryland.
Same in Maryland. Now, here's a really tricky point. A lot of times I'll meet with a client who lives here in Northern Virginia in McLean or Vienna, and has a home in Ocean City or a rental property in DC. And they know that the exemption is, 4 million or 5 million. And, a lot of times they'll say, like, I don't know how much my condo is worth, but believe me, it's not a $5 million condo. I'm not worried about it. But that's not how it works. When you own property in Maryland and you die, Maryland looks at the decedent's entire gross estate, calculates the estate tax and the amount above the exemption, and then prorates it for the value of your Maryland property with respect to the decedent's entire estate. So even if you own property in a jurisdiction and you think that, it's not worth anyway, it's going to be sheltered by the exemption. No, they look at the entire gross estate. So it wouldn't be a huge liability typically, but it gets complicated.
Okay, next question. We have you under the gun here. Persons without survivors, etc. Okay, it's best to name someone, but if that's not possible, how can one assign responsibility to professionals? I'm speaking to non-health issues.
Yeah, so you'd name a bank or a trust company. There's lots of bank and trust companies out there that will act as the trustee, for example. Oftentimes I'll email a client a list of 3 or 4 corporate trustees, and they can see what's a good fit for them.
Okay. Question, how much does DC probate court charge if you don't have a trust?
Yeah, I'm not sure what the exact numbers are offhand, but there's going to be court costs, which typically are not prohibitive. The expensive part gets, if you have to hire a lawyer. Of course, your executor is also entitled to compensation. So it's usually not the court costs that are driving this. It's the time, the aggravation, the attorney's fees.
Are there any other questions out there?
Yes, I wanted to ask you, as far as the DC estate tax is concerned, First of all, is there a succession tax in DC?
Is there a what kind of tax?
Succession tax? If you die, do your children have to pay
Yeah,
succession?
that would be the estate tax.
But so you do have that in DC, or I thought
We
it-
do. Yeah, there's a DC, it's called an estate tax. So when someone dies, we look at your gross estate, everything that you own.
And you have to do the same thing for federal taxes?
Correct. Yeah.
Well-
So if you live in DC and you have more than $4 million, potentially there's going to be a liability, a tax
She may
liability.
she may be thinking of an inheritance tax.
Yes, that's what I meant.
Mhm.
Inheritance, thank you. Inheritance tax. I
Mhm.
don't think you have any inheritance taxes in DC, do you?
Well, again, there's the estate tax, but there's not a
Goes on
separate.
on the house, let's say the value of the house.
There's also what's known as a step up in cost basis at death. So for capital gains tax purposes, let's say you bought your home at 400,000 and today it's worth 900,000. If you sold it today, you'd have a capital gain of $500,000.
Yes,
But if you died and your children inherited your basis, that 400,000 is stepped up to fair market value. So the kids could sell the home and not pay any capital gains taxes.
that's what I had heard, okay.
Mhm.
Thank you.
You're welcome.
I see no further questions.
I have one last question. When someone dies, what exactly what are you supposed to do? Who do you notify? Your lawyer? Do you go to probate? If you can tell the basics, because I've had that question come to me and I couldn't answer it.
Yeah. So what I advise my clients is that when someone dies, call us, call the Collins firm. You don't do anything until you talk to your lawyer. Sometimes people have this, I don't know, compulsion or well-intended desire to take action where they start calling people and the bank and the post office and the broker and no, don't do anything. First meet with the attorney. We'll let everybody know that you've died in good time. But sometimes it preserves a little flexibility and some options. So don't do anything until you talk to your lawyer when someone dies. So within a few weeks, 2 or 3 weeks is a good time.
How does one know? This it might be outside your scope of
Yes.
expertise, but we have a number of members who live alone, don't have family. And if they were to become incapacitated or die, how would people know who their attorney is, if they're incapacitated, whether or not they have a medical directive? Is there a mechanism for people to know where to look for the papers?
You can just do the obvious things like get a big tattoo on your chest. But you could put a note on the back of the door, put a note on the fridge, or maybe a card in your wallet
Mhm.
of who to call.
Okay, just sort of one of the file of life, which if anyone needs one, we have them in the office. Be glad to share with anyone who, I just was wondering if there was a more sophisticated way than that you were aware of. No.
Not that I'm aware of. Yeah.
One last question. In the case where the children finally inherit a traditional IRA after the two parents have died, does the child have to make distributions in years 1 through 9? We know it all has to be distributed out by year 10, but there's been some confusion as to whether in a traditional IRA, they also have to take distributions in years 1 through 9.
Yeah. So before the Secure Act, the kids could stretch
Could
out the
stretch,
inherited
right.
money based on their age and life expectancy. Now the general rule, they're capped at 10 years. There's some exceptions for
Right.
example, people with disabilities or someone
Right.
less than 10 years younger.
Right.
But the 10-year rule, there's only one rule. You don't have to take anything for the first 9 years. You just have to pull it all by year 10.
Yeah, I think that's they're rewriting now. The Secure Act 2.0 is now trying to make its way through Congress. We don't know what's going to happen with that. But there has been some confusion over the fact that maybe if you've already started to take required minimum distributions on the part of the parents, that the children have to take in years 1 through 9, also have to take an annual distribution, but it's a disputed kind of thing.
Yeah, I'm not aware of that requirement. But,
Okay, yeah, right,
and it's brand new. Yep.
right.
Erica, I think Job has a question.
I don't understand why I should call my lawyer first when someone dies, and what that lawyer is supposed to do. What's the lawyer
Just to give you advice, just to go over things with you and let you know what the next steps are. To see, if there's going to have to be a probate, if there's going to have to be tax returns filed, just how to handle the administration.
Okay,
But,
will the lawyer get to the funeral home, for example? Will he call the funeral home?
No. So after the funeral, in 2 or 3 weeks, you'll go meet with the lawyer. And then you discuss things like, for example, the step up in cost basis on your assets, filing the final income tax return. There's a whole litany of things that need to be thought about and considered at that point. Making the portability election.
Okay, thank you.
You're welcome.
Yes, I have a comment on that. I didn't mean to say that when the person dies, you notify your family and friends, et cetera, but a lot of people don't know that they have to go and file papers. If somebody dies, they think they've just died and that's it. That was the instance that I ran into. What do you mean I have to do this and do that? So,
Yeah.
and I also would like to add a comment that I live in the District of Columbia and my husband died in 1997. He was an attorney. And from what I understood from the attorney I had, they're the worst people to make wills, which you do. And it had
The cobbler's children have no shoes.
That's right.
Yeah.
It was in probate in DC and it took 3 to 4 years and it was accomplished. I got through it, but it was painful. So go do your due diligence and call the Collins firm and write up your papers.
Thank you.
All right.
It's true.
That's a good note to end it on. Thank you all very much. Call, email, if you have questions, you're welcome to come in. If you've got documents, I'll review them. Free consultation.
Good. Thank you.
Thanks
Thank
a
you
lot,
very
Phil.
much.
Thank you.
You're
Very
welcome.
informative.